So Judge O'Connor has issued his decision, which is blocking the ATF's pistol brace rule. So let's talk about this. But real quick before we jump into this video, if you think the ATF's pistol brace rule is clearly unconstitutional, go ahead and hit that like button and subscribe. Also, I want to thank one of the sponsors of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee and they're huge Second Amendment supporters. They have some dedicated roasts for organizations like FPC, and so some of those proceeds go directly to those organizations so they can file lawsuits like this one here in Mock v. Garland. So again, amazing coffee. If you guys are interested, you can check them out using the links down below. And if you use the code ARMSCHOLAR, you can get 10% off of your order. So like I mentioned in the intro, in this video, we're gonna be talking about the decision that we just received from Judge O'Connor in the Mock v. Garland ATF pistol brace lawsuit. A lot of you guys were asking me what was going on. You may recall that recently the Fifth Circuit sent the case back down to Judge O'Connor for him to issue a new decision on whether an injunction should be granted against that ATF pistol brace rule. The decision was required to be issued within 60 days, and we just got that decision. Judge O'Connor has granted the injunction which prevents the ATF from enforcing their new rule, essentially against FPC and their members, Maximum Defense and their customers, along with protections for the individual named plaintiffs in the lawsuit. A nationwide injunction was not granted by Judge O'Connor, but he did continue the protections for FPC and their members like we had all anticipated. That also means that other organizations in their lawsuits, like the GOA lawsuit, and then also the SAF lawsuit, will also get similar type of relief in their case. Now, for those who may be confused about what's going on, why there was no nationwide injunction, and really what this decision is going to do and where this goes from here, originally in the Mock v. Garland case, the federal district court judge, Judge Reed O'Connor, denied a preliminary injunction that was requested by FPC. Now, after that decision, FPC did file an interlocutory appeal up to the Fifth Circuit Court of Appeals. And in response and on review, the Fifth Circuit granted an expedited review of the case, but also granted a temporary administrative injunction, which halted the pistol brace rule, and that was specific to just FPC and their members and some of those named plaintiffs. Then we saw other organizations like GOA and SAF piggyback offer those protections and get similar protections for their organization and their members. Now, the Fifth Circuit then reviewed the Mock case and found that plaintiffs should have been granted the injunction originally by Judge O'Connor, especially on their APA claims. The Fifth Circuit found that the ATF went beyond their statutory authority when they put in place the pistol brace rule, and then also that they violated the APA by modifying the rule drastically from the proposed rule to the final rule. They focused heavily on the worksheet 4999 that was in the proposed rule, but then was removed in the final rule. The Fifth Circuit then remanded the case back down to Judge O'Connor for him to redecide the pistol brace injunction in light of what they just said. One of the critical things on the remand was that the plaintiffs were given the one main factor, which was likelihood of success on the merits. Well, again, late Monday night, we got the Judge O'Connor decision and he issued an injunction blocking the ATF pistol brace rule. In the decision, Judge O'Connor starts his whole analysis by pretty much wholesale adopting the conclusion that the Fifth Circuit came to, that the plaintiffs had a likelihood of success on the merits. Then he moves on to look at the remaining factors, and then he first looks at irreparable harm, and in looking at irreparable harm, he found that the court finds that Mock, Lewis, and other individual FPC members are threatened with irreparable injuries in the absence of an injunction. The threats to individual FPC members are twofold. First, sustaining permanent and non-recoverable costs from the compliance with an unlawful issued regulation. And two, suffering impairment of their fundamental right to keep and bear lawful arms in self-defense. The court finds that such threats of irreparable harm posed by enforcement of the final rule are credible, imminent, and intertwined with one another. So here Judge O'Connor is finding that there is clearly irreparable harm to individuals, both monetary harm that cannot be recovered even when you're compliant, so the compliance costs can never be recovered from the government, and also, and more importantly, there is irreparable harm against the fundamental right to keep and bear arms and keep arms for self-defense like braced pistols. Judge O'Connor in his decision goes on to state that the situation becomes far more dire for the FPC members in the absence of the court's intervening protection when one considers the burden the final rule threatens to impose on their fundamental right to keep and bear arms in self-defense. In this litigation, plaintiffs allege that the government defendant's promulgation of the final rule violates their constitutional right provided under the Second Amendment. Separate from the merits of this claim, the court finds that the government defendant's implementation and enforcement of the final rule substantially threatens to inflict irreparable constitutional harm upon the FPC members. Absent injunctive relief, the final rule will impair and threaten to deprive them of their fundamental right to keep and bear commonly used arms as a means of achieving the inherently lawful ends of self-defense. So here Judge O'Connor is touching on how braced pistols are in common use for lawful purposes, and therefore the ATF and their restrictions on these types of braced pistols and these types of firearms is a restriction on arms and conduct that is protected by the Second Amendment. He goes on to state in the decision that the court finds that the braced pistols subject to enforcement of the final rule are in common use today. For starters, it is undisputed that pistols such as those in the FBC members' possession are on their own and without stabilizing braces already deemed to be among the weapons most commonly used today for lawful self-defense. A stabilizing brace does not somehow alter that status and effectively strip the pistols of their Second Amendment protection. The government defendant's assertion to the contrary, that pistols do become dangerous and unusual as soon as stabilizing braces are attached to them, does not survive its own administrative record. Now, here in this section, Judge O'Connor destroys the ATF's argument that braced pistols are not in common use for lawful purposes, and he just rejects their argument that these type of braced pistols, the second you put a brace on it, all of a sudden makes it an SBR, and it's a dangerous and unusual item that can have restrictions on it. He points out that the ATF's own actions and their rule itself show that these are in common use for lawful purposes and does not meet that type of definition. Now, it's important to note that in this decision, Judge O'Connor does not do a full Second Amendment analysis under Bruin. Instead, he just establishes whether the Second Amendment and these rights associated with the Second Amendment are likely going to be harmed by the ATF's new rule against pistol braces, and essentially just for the point of whether or not an injunction must be granted at this stage of the lawsuit. He also looked at the potential harm that the government may suffer, but he finds that the government cannot claim that they will suffer any type of harm because they actually violated the APA in creating the rule. So that pretty much just voids any potential harm that they could claim just outright. And then also the harm to the plaintiffs and the burden on their fundamental rights and the non-recoverable costs clearly outweighs any harm that the government could even claim despite them violating the APA. Therefore, he goes on to grant the plaintiffs their preliminary injunction against the ATF's pistol brace rule. Now, in this decision, he did decline to the request to issue a nationwide injunction. I know a lot of people were curious if they would actually get the nationwide injunction, but here Judge O'Connor is leaving the injunction limited to the one that was in place prior. Now, the question is what's going to happen going from here? No doubt the ATF will seek an appeal. The issue is that the Fifth Circuit has already ruled against the ATF. They've already shown that they believe the plaintiffs have a likelihood of success on the merits in this case. So it's going to be a hard claim, to the Fifth Circuit that they should somehow issue a stay against this injunction. Maybe what may happen is the ATF decides to try to bypass a 3-judge panel review in the Fifth Circuit. Maybe they try to go en banc. The ATF hasn't even liked that option recently, so they've sometimes even bypassed that and gone straight to the Supreme Court. The ATF has had success in the Vanderstock case in getting emergency application granted by the Supreme Court and getting an emergency stay by the Supreme Court, especially in the frames receivers case. But remember, the Vanderstock case dealt with an ultimate merits decision that was on a summary judgment granting, and it was also a nationwide vacature of the rule. This pistol brace case is still at an interlocutory posture, which means it's not an ultimate merits decision, and there's still a more limited injunction that was granted in this case. It wasn't a nationwide vacature of the rule. So it's going to be interesting to see how this case proceeds forward, what the ATF decides to do. The ATF loves to appeal these cases, so I suspect that there's going to be some sort of appeal, of course, and then also probably some sort of request for a stay on this injunction. The plaintiffs will likely now move for a summary judgment, probably in this case, even while all this other stuff is happening in the background, try to get a similar relief that happened in Vanderstock. And also, I fully suspect that some of these other district courts in these other cases, like the GOA case and the SAF case, will grant similar injunctions that protect those organizations and their members as well. So again, if I get any more information, I will let you guys know. Also, if you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos in this type of 2A news. A lot of you OG fans here know about how to fuel the algorithm. So again, thank you guys so much for all of your support. Also, a lot of you guys are mentioning that you've been unsubscribed from the channel. Just double check that you're still subscribed to the channel. And also, I just want to mention about 60% of all viewers here on the channel are actually not subscribed to the channel. So please, if you watch these videos quite frequently, I'd appreciate if you subscribe to the channel. And also that signals to the algorithm that this is important news, that it's important information, and that they should push it out to more people. But regardless, thank you guys so much for all of your support. As always, don't forget to like and subscribe. And never forget, the station was built by armed scholars, and the station will be maintained by armed scholars.